And with that, we'll pivot to our next panelist, Smita Ghosh, who is appellate counsel of the Constitutional Accountability Center. She's also lead author of the amicus brief for constitutional law scholars. Would you, Dr. Ghosh, please share with us your view of how history does or doesn't or hasn't or will play a role in how the court viewed this case?
Sure, sure. Thank you. Just starting out, thank you so much to all the co-panelists and to SU for arranging this. I work at Constitutional Accountability Center, which is a law firm and think tank that tries to use history to inform constitutional and statutory debates. And we regularly file amicus briefs, including the one that you just referenced. So I did have the opportunity to think a lot about the historical evidence in this case. And I know that Professor Brewer is also on here and filed a great history brief as well. One thing I thought I could emphasize as a starting point is just that there's no constitutional provision stating that the president cannot be tried for actions taken during the presidency. And there is historical evidence suggesting that that was intentional, that the framers considered the opportunity to create some kind of textual provision and explicitly rejected it. There, in the drafting history, Madison raised the possibility of attaching some privileges to the presidency, and it wasn't addressed. Nobody took him up on that invitation. So the majority opinion didn't use the text of the Constitution, and they didn't use much history either. They reasoned a lot from what I thought were more like free-floating separation of powers principles, penumbras, something like that. One thing that felt important to mention was a civil immunity case from the 1980s called Nixon versus Fitzgerald. That was a case involving President Nixon, at that point a former president, and asking whether he could be liable in a civil trial for actions that he took as president. So a civil trial meaning just for damages rather than with the possibility of being incarcerated. And the Supreme Court there recognized, using again these like principles, that the threat of civil suits about official actions could really hamper the president's decision making. And I wanted to bring this up just because I'm curious what other panelists thought about this, because the court did try to explain why that threat of kind of hampering the president's decision making, making them unduly cautious because they're worried about being sued, why that would apply in the context of a criminal prosecution. But to me, Fitzgerald was kind of about a balancing test. What's the interest to be preserved by letting the suit go forward versus the interest in protecting the presidency? And it just seems like at least arguably, there's a lesser public interest in action for damages than there would be for criminal prosecution. And this gets a bit circular, but just thinking that prosecuting someone and deciding to prosecute someone is part of the executive power. That's an interest of the executive branch of the sitting president. And then, so to say that it should be kind of held back because of the interest of the former president, I just found that really interesting. And I wasn't totally expecting the court to go there in its reading of Fitzgerald. So then thinking a little bit more about you asked about the history, there was quite a lot of supportive history, I thought, that the court disregarded. I was expecting a little more, I guess, engagement with that. One thing that I found, I'll just mention it, that I found especially convincing, that I relied on a lot when preparing this brief, was an article by Sai Krishna Prakash. He's a professor at University of Virginia and has written a lot about kind of pretty broad theories of executive power. And he has an article called Prosecuting and Punishing Our Presidents that is about why the president is not immune. And I think he even extended his conclusion to a sitting president, not just a former one. So a lot of this is a story about kind of not just like what history is there, but what work do you want history to do? And I think that's where the majority and the dissent really differed. So, for example, there's a lot of statements from members of the founding generation, including some of the ones that worked on drafting the Constitution, that kind of directly acknowledged or shared a presumption that presidents could be prosecuted. Justice Sotomayor cited what I thought was a pretty convincing example of this in her dissent. It was a quote from James Iredell, one of the framers of the Constitution, later a Supreme Court justice, president of the North Carolina ratifying convention. And he said, if, I'm quoting, if the president commits any crime, he's punishable by the laws of his country, and in capital cases can be lose his life. So that's, for Sotomayor, was really convincing evidence that the framers wanted the president to be accountable, that the absence of text on this protecting the president from prosecution was intentional. But for the conservative majority, this just wasn't enough. The opinion kind of pointed out, it addressed that quote from Iredell and said, well, we don't know if he was talking about official actions or not. So we can't really, like, that's not directly on point. So that to me was just an example of kind of using history to ask different questions and to expect different amounts of kind of specificity. And that's attention, like in all uses of history, not just in this type of case. And I thought the same thing was true for what you would call like historical practice or post-ratification of the Constitution. For the dissenters, it was really relevant that for years people have acted like presidents were not immune from prosecution, even for official actions. There's like Ford pardoning Nixon, the Office of Legal Counsel writing in a memo that concluded that sitting presidents shouldn't be prosecuted, but once they leave office, of course, they can be. It's sort of like almost as an aside. So the majority looked at this practice really differently. It said, well, at the bottom line is that a Supreme Court has never addressed this question before. No one has ever raised presidential immunity. So it's really like, there's really nothing there for us to look at. A line that jumped out to me was, all that our nation's practice establishes on the subject is silence. So there's just to me, that was just kind of a sobering moment about like what history and historical evidence can and can't do in these types of debates. Like a cynical read is just kind of like, you can always shape the evidence to support or not support the argument you want to make or the conclusion you eventually want to end up with. But maybe a more measured way to put it is just that historical questions always change depending on the way you frame them, and then evidence becomes relevant or not relevant.